Good evening. Thank you all for coming. My name is John Kortmansky, and I am the president of the Law Alumni Association. And I want to thank you all for coming to this incredible event with this tremendous panel. And knowing how good they are, the best thing I can do is be very brief so you can hear those folks you came here to actually listen to. The name of this event, as you know, is A Stroke of the Pen and the Bully Pulpit, The Power of the Presidency. We have an incredible panel, and I want to thank each of the panelists for joining us tonight. This is a topic that is as timely today as it was when George Washington first got elected as president, and I am really looking forward to hearing how things have changed since that time. Before getting started, I want to thank the LAA Fall, now Spring Committee for helping plan this incredible event, and I specifically want to give thanks to the chair folks, Sarah Davidoff, Alan Klinger, and Stephanie Wolf. Now, allow me to introduce our moderator, Bob Bauer. Among other positions, Bob was White House counsel to President Barack Obama and co-chair of the Presidential Commission on Election Administration. And he now is a professor here at NYU, to our good fortune. And with that, I turn it over to you, Bob.
Thank you very much. My very distinguished panelists, co-panelists here have agreed that we're going to cover a number of topics under the general heading of presidential power, and we're hoping to get a discussion going and hit as many as possible in the time allotted, and then also leave time for questions and answers. And we're going to do so with a view toward also trying to put some of the contemporary activities, contemporary views of the presidency, contemporary controversies surrounding the presidency in some sort of broad or historical perspective, if at all possible. And I can say, as somebody who goes back and forth between Washington and New York, there is nothing like perspective, and you're not going to get it in Washington. So let me begin the question, first of all, on a matter of domestic authority, the president's domestic authority. So we have heard from some distinguished scholars like Michael McConnell at Stanford that there's been a steady increase in the powers that have been, if you will, seized by presidents, the powers that have ultimately accreted to the presidency and that Congress has not sought to resist, and that it's the trend that's built over time, but it's accelerated under the presidencies of George W. Bush and Barack Obama. And now we have the presidency of Donald Trump, and we'll make an assessment of where that stands. But because of the day's news, it might be helpful to talk about a topic right off the bat that's very much in the news, and that is the relationship between the White House and the president and the system of justice at the federal level that we have. And obviously there's been much discussion about how and in what ways to enforce independence in federal law enforcement. So I'm going to walk or move here from my left all the way down and begin appropriately with Preet Bharara, whom all of you know very well, and who's going to speak on this subject with great authority, as will my co-panelists from their different perspectives. And let me just ask this question. If we are going to take the long view here, and even accounting for the current controversies, would you say that there's been a decisive institutional shift that has accounted for, a troubled relationship between an independent justice system and a president? Or is it not an institutional shift and more a reflection of individual presidents and what they think they are able to do or get away with? Preet.
That's a great question. It's good to be, look, I understand presidential power personally. The president has various powers with which I am now intimately familiar, including the power to fire United States attorneys. I'm one of those people. Look, I think it will take some time, right? I think historically, without mentioning any examples, because I haven't read up on my history going back to Washington just yet, but institutional change probably follows the changes that are wrought by individuals who seek to change the institution. So I think you can say that in the first 13 or 14 months of this presidency, that there is certainly an interest on the part of Donald Trump to expand even further what has already been an expanding presidency, power of the presidency, as you mentioned. And then the question is, how much leeway does he get? How much is he able to get away with? Whether you're talking about the usual norms of dealing with the Justice Department, which is the issue that you first mentioned and that I care about very deeply, or is he going to be constrained in some way? And sometimes constraints are put on the president so that these changes are mostly personality-driven and don't become institutionalized because people are fed up with it and they push back. And that's one of the projects I'm working on with the Brennan Center and with Governor Whitman to try to propose ways in which we might codify norms that are being violated into hard laws. And right now, it seems that Donald Trump, based on, I think, reasonable evidence that you find in 140, now in 280 word increments, has a view about how strong the presidency should be. And one piece of evidence in favor of that conclusion is his admiration for other people in other countries who don't have this system and have different institutions who he seems to admire at a minimum, and also is incredibly loath to criticize. I mean, the president has, I think, indicated his affection for and desire for more executive power when he calls President Erdogan of Turkey, a person with whom I have some experience as well, and congratulates him on his expansion of power. When he says about President Duterte, they don't have a drug problem in the same way in the Philippines like they have here, because they engage in extrajudicial killings. So, for now, and I'll leave it at this, and we can talk about specifics if you want, it seems that the President of the United States, his personality is such that he wants more power. I think his personality is such that he wants to change the institution and the relationship between the two institutions of the presidency, the White House on the one hand, and the Department of Justice on the other hand, combined with finding himself in the position of being, I suppose you could call him a subject or a target of a special counsel investigation, which I think goads him further for reasons that are not completely, they're somewhat more understandable, even if it had been someone else, that he's pushing in that direction. And the question is, will there be people in the Justice Department, when they are told to pursue his adversaries or told to hold back with respect to his allies, and or if he fires Bob Mueller or engages in some conduct that's, I think, extreme like that, will Congress push back? So I think the jury is out on what's going to happen with the institution, but the jury, I think, is very much in on what Donald Trump would want to do if he had his druthers.
Richard, do you
yes,
agree that the suggestion there is that this is a sea change and more individual than institutional in character?
I actually think, as with all of these questions, the answer is both. There is no question that as you increase the size of government and increase the number of people who have powerful positions in Congress and so forth, a unitary president will systematically get advantage over divided coalition-type governments. And that has certainly been true at least since the George W. Bush administration. The Constitution was drafted for a nation of 3 million people. It's now 100 times that size. We have many more government officials because of the Commerce Clause expansion and so forth. And I think unitary actors in general will do better than a coalition in Congress in order to figure out what's going on. So I think to some extent this stuff is independent of persons and it's a matter of scale. And that was, by the way, one of the themes that I taught when I used Mike McConnell's constitutional law book, is that things that work well with small governments don't work with big governments. So you need an administrative state and all sorts of other stuff to do it. With respect to Trump, I think it's actually a genuine paradox, and this is not meant to give him any credit. The first mistake he made was gratuitous, stupid, and individual. What he did is he decided to take somebody and appoint him as Attorney General who was very active in his own campaign, and it was a sitting senator. And the basic rule that you have when you appoint somebody is you never appoint somebody who is, in fact, to an independent office, is supposed to have plenary power, where he himself may become part of an investigation, given all the irregularities that may or may not have happened during the elections. He was too close. And then, given the very precise standards that we have, if you start to misspeak in any way, shape, or form, and your sessions, you then start to disqualify yourself from some things rather than from other things. So Donald Trump has 2 attorney generals, one of whom he picked who can't do what he wants, and the other one whom we did pick who will do exactly didn't pick will do exactly what he did want. And I think part of the tantrums and the acting out that have actually taken place in this situation don't come from an abundance of power that the man has. I think it comes from the fact that he regards himself as less powerful in his office in terms of what he can do to regularize ordinary affairs than anybody else who's ever held that position beforehand. And indeed, my own view is that if somebody comes up and says, I'm going to nominate you for Attorney General, and the Senate is asked to confirm on the grounds that he doesn't deal with X, I don't think that's permissible. I think essentially you have to either take the whole office or none of the office. You cannot use the consent power to negotiate a fundamental change in structure, and that's exactly what we got in this individual fashion. Well, then what you do is you combine this with two things. One is a frustration level which knows bounds, and this is individual. If you are somebody like Donald Trump, used to working in a corporate environment, the words "you're fired" actually carry with them a certain degree of resonance, and people have been known to be carried out of offices, if necessary, in chains in order to make it good. You tell somebody in government or even in a university you're fired, and they'll look at you kind of puzzled and go on exactly the way in which they have done, right? So if you
Not always.
Well, certain people in the executive branch may well be subject to that, a topic which is there, but it's certainly not going to be true of everybody in the Congress, everybody in the judiciary, and so forth. And he is just frustrated because he doesn't understand the environment. Now, I'm just going to make one last point. What temperament do you need to have in order to be a successful political operative who doesn't have the power to hire and fire everybody? And it's not a talent that I particularly have, but it's one called patience. What you have to do is be able to talk to people, to win them over slowly, to engage in compromises and careful negotiations over things. And if you try to figure out somebody whose temperament is utterly unsuited to those sorts of patient renegotiation, DJT essentially scores off the Rorschach chops on this one. And so what you do is you get a guy with an extremely difficult temperament, facing a very difficult world situation, disarmed over some key positions, and he does what any mature gentleman in that position will do. He acts out like a child.
Lisa, you're someone on this panel who's had a significant amount of experience in Maine justice. You know the criminal justice process. Let me say what you will, obviously, in response to the previous comments, but Richard referred to the position of Attorney General, the post, as an independent post. Mm-hmm. To what extent are we right to think of the Attorney General and the position of the Attorney General as an independent post?
So I'll answer that. I will also say I don't think Donald Trump spent a whole hell of a lot of time thinking about the unitary executive. I'll just say that. And I think it's because he is quite, it seems, contemptuous of expertise, subject matter expertise, and institutional expertise. And you see that in his dealings with, in particular, the Justice Department. Now, to answer your question, I think that the describing the Attorney General as an independent actor only gets it half right. And the reason I say that is because what I think people don't often understand about the role of the Attorney General and the role of the Justice Department writ large is that, in fact, it is unique in the cabinet and amongst federal agencies as in holding a dual hat and operating under a dual hat. What do I mean by that? The prosecutorial and investigative function of the Justice Department and the lead and largest investigative part of the Justice Department, the FBI, is supposed to operate independent of any political influence. That said, the Justice Department has and the Attorney General and the rest of the political appointees and the other appointees in the Justice Department have a role in the policy process and in carrying out the policy priorities of any president, and that's quite appropriate. The rub comes, however, that in so exercising those prosecutorial or those policy priorities, the investigations and prosecutions that follow must be done free of any influence. So any president is well within his or her right to say, I'm going to make jaywalking, if there were a federal crime, the main priority of my administration, and I want all the resources and all my US attorneys to go out and prioritize that crime. That's fine, and everyone should fall in line, but then the individual prosecutions and investigations of those crimes must be done completely free of any political influence. So I think that is a distinction that often gets lost when we just kind of paint the Attorney General as an independent actor. I say that believing extremely strongly in the half of the hat that the Attorney General and the rest of the Justice Department must wear in their independent role. And having spent about 15 years in the Justice Department in various roles, both career roles as a career prosecutor and in politically appointed positions under both administrations, of both parties rather, and feeling that in either case and under either party, that independent role has got to be rigorously observed.
One sentence. I didn't say independence, I said partial.
Okay, fair enough.
And it's very different, because in the areas that are controlled, it could still be, you observe Lisa's control.
Well, then let me ask for a lightning round of responses, then we'll get off this particular topic. The following question. Let us assume that the President of the United States reads in the newspaper about, some scandals reported, financial scandal, whatever the scandal may be. It attracted an enormous amount of attention. And then, by the way, as happened during the Obama administration, as you recall, in relation to what people observed of conduct on Wall Street during the 2008 recession, there was an outcry that not enough was done to bring the most senior executives who might have been responsible for some form of wrongdoing to justice. In your view, beginning with Preet, would it be inappropriate, and let's take Donald Trump out of the picture, let's bring President Bernie Sanders into the picture, or President Elizabeth Warren into the picture, for that president to pick up the phone when those indictments are not forthcoming and public criticism is beginning to mount? Would it be inappropriate for the president to call and say, I'd like an explanation, having read, for example, this expose today in the New York Times, why it is that a case has not been brought against X, Y, or Z? Explain it to me. Is that undue pressure from the executive, and how do you distinguish the policy from the prosecutorial function in that situation?
Look, like with everything else, the devil is in the details. I see all these reports. I'll answer that question in a second. But I keep getting asked on television and in other contexts and in panels like this, is it inappropriate for Donald Trump to have done what is reported by anonymous sources in the New York Times? Whether it's an attempt to fire Bob Mueller through Don McGahn, who has a job that you used to have, or it's talking to Jeff Sessions about potentially backing off on Joe Arpaio. And my unsatisfying answer to all of those questions is, it depends. It depends what the nature of the inquiry was. It depends on what the language used was. It depends on how forceful it was. So the example you give, there's a spectrum, right? And you count on members of the executive to appreciate and respect the sort of division that Lisa talked about and the arm's length nature of the relationship with respect to specific enforcement actions, but there remains a continuum. If there's a fire that burned down a building in a neighborhood, and the mayor says, to take it out of the presidential context, and the mayor calls up the district attorney, who, by the way, doesn't work for him, so maybe it's not the best example, and says, I need you to make sure you figure out if this was an arson, that you get the guys who did this. And I think that's natural and normal. Like you might say after a financial crisis hits, I think it would be appropriate for the president to say, in the safest zone, a lot of people were hurting. If there were crimes committed in connection with this, I want you to make sure that those people are brought to justice. On the other hand, if a president calls and says, at the other end of the extreme, you know what, I really think that so-and-so, who is the head of such and such bank, I've never liked him, he didn't donate to my campaign, he's ruined the lives of a lot of people. I applied there once to be an intern after I went to Wharton and I didn't get in.
By the way, this is called loading the hypo.
Well, but I'm
I want to be in Preet's class.
I'm talking about the bookends, right?
Okay.
Like that's an example of something that I think most reasonable people would say is incredibly egregious and wrong and impinging on the independent function. It gets harder, and that's why I'll pass it along to these folks. If you talk about, it's a harder question. So between those two end zones, if you have, for example, and I'll give you a real life example, and I believe a phone call like this may have happened. I'm not positive. It was in the news, and Lisa and I just talked about this in my class. It was in the news in 2010 that the Toyota Motor Company had engaged in conduct that a lot of news organizations were reporting about, and it was unclear whether or not crimes had been committed, and there was a safety problem, and there was a question about whether or not they had been completely candid and transparent with the Department of Transportation about this problem they had with keys in the ignition. And that was on the news every day. It was a lead story every day. So if the question presented is it in the context of that, if a president were to call his people in the Justice Department and say, on the one hand, hey, is something going on here? Like, what is going on here? Are you guys on this? I think you have to be very careful in how you have that conversation. That's probably on the other side of the line. If, on the other hand, the conversation is, on that particular topic, is more along the lines of, we're getting killed here. I promised the American people that we were going to hold corporations accountable. You better have 3 people arrested immediately, because from what I read, it sounds like there are criminals here. That's probably on the other side of the line. But I think, presidents have the right and ability to be concerned about public safety, to be concerned about national security, to be concerned about people being ripped off by Wall Street or any other entity. And what they need to have is some sensitivity to the issue. I mean, I had dealt with this question when I worked in the Senate. I worked in the United States Senate for 4.5 years for the senior senator from New York. And at the time, we had to discuss protocols for ourselves, for not just for ethical reasons, but for the protection of the senator. When a constituent calls, and it's not quite the same thing, but it's an issue that comes up not just for the president, but for individual members of Congress and individual politicians all the time. And some of those you investigate when you're the United States attorney. What is the difference between, doing something that's in the category of being a representative for people who are your constituents to make sure that they're not getting hurt, versus putting the thumb on the scale in an enforcement action? And the problem with all of this, when you have a norm-busting president, is and the same true with prosecutors. You can't outline every single scenario and give someone a script for every single phone call that you might want that president to have, who in good faith wants to make sure that people are being held accountable. You can't script it all out. What you hope and expect is that you have general guidelines and rules, and that the person who is thinking about making the call and having the conversation has a temperament, character, judgment, sensibility, fairness, neutrality, sense of arm's length, so that conversation falls on this side of the line versus this side of the line.
Richard?
Let me actually answer the question that you precisely put on financial stuff and talk about 2 particular cases, one of which I was involved in and the other not. As a general matter, if a president sees a political situation and calls chief officials and asks them to say, what's going on? Is there somebody here I ought to hold accountable? I think those discussions are privileged in general and are not of consequential until they actually translate into some external action where you go after people. So the 2008 crisis, which was a Bush crisis, resulted in sort of serious kinds of problems. And the question is whom you point your figure at. And Bob skewed the inquiry by referring to the New York Times and not to the Wall Street Journal, right? And if we then start to put both of them in, you actually could see what the difference is. There was clearly a breakdown in the whole banking system in 2008. And if you're a New York Times supporter, you tend to think of it as greed, Wall Street, bad models, and so forth. If you're a Wall Street Journal guy, what you will do is you say, you know what we did is we had pushed too hard on the Community Redevelopment Act by demanding very large percentage of loans for low and middle income or moderate income families. Then what we did is we gave an implicit guarantee that if somebody did these loans, that they would be bailed out. You put those 2 things together, you got yourself a terrible problem. And there's a very different kinds of responses that you have. And to the extent that that second explanation bears any weight, it's going to make it very difficult to pursue either civil or criminal prosecution with respect to the first. And so in that case, I think it would be improper to prosecute, no matter who you are, unless you can find a kind of non-structural explanation which points to invidious intention by one or another actor. The other case in which I thought the Obama administration acted quite improperly was when they found out all of this stuff with respect to bank meltdowns and so forth with respect to the Madoff scandal. They managed to extract $12 billion in settlement from, I guess it was J.P. Morgan Chase, on the grounds that it did not warn everybody in high powers of what was going wrong. Let me just mention a couple of facts why I think this was egregious. One is there was an exhaustive study done by the SEC about its own incredible incompetence on this thing. You go read the 250 pages. Actually, you don't read it. You just put in the word Madoff and see if it's there, and it's not. Then you will figure out what his functions were, and he was basically having nothing to do with investments. He was just making disbursements, that particular bank, one way or another. And if it turns out that you have systematic failures that start to take place elsewhere in the system by people who are directly responsible, some in government and some not, it seems to me to be a very serious breach of a sensible criminal procedure to start doing this. To make it worse, and I think this is a topic which one has to always think about, there is something known as deferred prosecution agreements in which you can make very strong threats of license losses and so forth in order to extract very large settlements, larger than you could get if there were actually a conviction on these things. And I think that's a real possibility of abuse when any attorney general in any administration does it. And this goes back at least to the Clinton administration, through the Bush administration, and of course to some extent through the Obama administration and so forth. And I think in general you don't want to have those kinds of operations. So what I would want to say about this is that if you're going to respond to that, you really want to sort of think fingers in the till type cases before you want to move. That is, in general, I agree with the non-populist critique that structural reasons tended to dominate the banking failures. And just by way of closure, I did work on some of the Fannie and Freddie and AIG reorganization cases, and I thought the government's behavior with respect to Fannie and Freddie was beyond dreadful, particularly in 2012. And I thought that the AIG thing was a really complicated mess, but in effect that the case against the government for the way in which it organized the restructuring was probably illegal. So it's not as though when you're doing these kinds of things that you have to worry about only one problem, which is private abuses. You really have to worry about administrations feeling the heat on them and then taking it out on private actors who don't merit the kind of criminal prosecutions or civil threats that are lodged against them.
Lisa?
Well, one observation and one comment. The observation is my co-panelists have redefined the meaning of lightning round. One comment. I read both papers every day, and I think that the answer to Bob's question is no. No, there's nothing wrong with the president calling up and asking the question that Bob posed. The question Bob posed was, I'm reading this in the newspaper, what are we doing about it? That, I think, in Preet's continuum is fine. And it is only by doing something about it, i.e. conducting an investigation, that you could reach the conclusion that Richard lays out, right? Determine what facts may or may not be present in any of the examples that he laid out. So I think that that question is perfectly appropriate. I actually think, however, the better practice would be for the president to say to his White House counsel, I read this in the paper. I want to make sure the Justice Department's all over this. And an administration that observes the norms between the institution of the White House and the Justice Department and maintains scrupulous observation of those lines and is attentive to the appearance of impropriety that may attain to veering from those lines, might ask his or her White House counsel to call the Deputy Attorney General or the Attorney General to say, want to make sure that you guys are on this, period, end of story. Therefore, there can be no misperception that there is a particular focus on an individual or a campaign contributor and the like. So I think that's the better practice. And an institution and a White House and a presidency and a White House counsel and an Attorney General who has the characteristics that Preet laid out would be attentive to that and the dangers that can fall to a president who does not observe those lines. The last thing I'll say is a good Attorney General has a role in this as well, which is to say you actually do your best protection of the president when you maintain those lines, right? When you are, as the Attorney General, scrupulously adhering to those lines, because you're doing the best protection of the president and the presidency if you do not have he or she vulnerable to those misperceptions that those lines are being obscured.
Can I just add a personal note to that? because that's exactly right. Some may know that, a little over a year ago, the President of the United States called me. The sitting United States Attorney in the Southern District of New York with jurisdiction over a lot of things, but including his businesses, the businesses of his associates, where he lives. And, what that would look like, and the reason I decided not to return the phone call, with the full blessing, by the way, of the Chief of Staff to Attorney General Sessions, was not only for my own protection, it was actually less my own protection, it was for his protection. Mm-hmm. And for exactly the reason that Lisa points out. Because a week later, a month later, it's not going to be clear, what happened. And in the same way, by the way, the last point I'll make about it is, there are some people who have suggested, Paul Ryan among them, that on this issue of the division between and the arm's length nature of the relationship between the White House and the Justice Department, Trump maybe should be forgiven because he's new to politics, he doesn't understand the protocols, and that has some surface appeal because he engages in a lot of things that he doesn't know much about. But in this particular regard, I think that's an indefensible defense of the president because he got to office in part because he actually exploited an appearance issue that occurred on a tarmac where the then Attorney General of the United States, Loretta Lynch, met with the husband, Bill Clinton, of someone who was also a candidate and was being investigated by the Justice Department and the FBI. So he full knew when he was going to rally after rally after rally what appearance problems arise from that. And at the same time, a few months later, he puts me and other people in the similar kind of appearance problem situation. And he needs to understand, like a good president should, that it's partially for his own protection as well.
This is a problem which is endemic to people who have arbitrary power in private affairs. What everybody's saying, and I agree with this having never set foot in any government position, is that whenever you want to give orders, you have to give them through channels, because the moment you jump reporting links one way or another, you undercut the person in the middle and you put the person at the bottom in an impossible position. But if you basically think that the government is your private satrap, which you could run at will, you will ignore all these niceties, and after the fact, it will just cast suspicion on everybody who's involved in the transactions.
So when we conclude, I want to talk about whether you really can address, Preet, some of these issues with a codification scheme, because the norms are collapsing, and therefore you start to cast into law what you previously enforced by norms. But just to move the topic along, let's talk for a second about national security, because I want to bring in the role that the Congress has to play, maybe the complicity of the Congress, in some of the issues we see with the exercise of presidential authority. And so we'll start on Lisa's end and move toward me again. Congress has been offered repeated opportunities to take responsibility for decisions that presidents, through the bully pulpit or the stroke of the pen, ultimately took upon themselves. One could argue there's a systemic problem here in that people expect a great deal from the president. The president has to answer for inaction, if you will, politically, and if Congress isn't cooperative, the incentive for the president to act on his own is powerful. Use of force decisions in particular. Repeatedly, Congress has been offered the opportunity to rectify an imbalance between congressional and executive authority in the exercise of the use of force. How does the executive respond to congressional acquiescence? Or is it also a case that Congress doesn't want to act because it's politically more advantageous to wait it out on the sidelines, take credit if it works, criticize the executive if it doesn't?
So you say acquiescence, I say abdication. Look, on the one level, we're in a law school, so it's right to have discussions of the unitary executive and theories of presidential power and the War Powers Act, and all of that is a perfectly lovely plane on which to have the discussion. But at the end of the day, when you are sitting in the president's seat, and seeing the daily intelligence reports and having to and being held rightly accountable and take an oath to protect the United States, you are the one who has the capability to act, right? Now, I think we have seen a growing, and I think quite concerning, abdication by the Congress when it comes to use of force decisions. The most, two great examples of this that get bandied about, of course, are the failure to act on an authorization for the use of military force with regard to the campaign against ISIS, and the failure to act on a request for a vote on the use of force in Syria. And, we can debate on a policy level, whether or not that the decisions taken by the Obama administration in those instances were right. We can have debate about the legal contours of the AUMF and whether they obtained to the campaign against ISIS. But at the end of the day, the president has a responsibility to act. And I do think that there is a growing, again, I would say, abdication. And much of this has to do with the last point you made, Bob, which is that there is great electoral peril in, as folks have seen in the past, with taking votes on the use of force, as many, I think, folks who ran for office after the Iraq war decision would testify to, and that there's been a tremendous reluctance on both sides of the aisle to take hard votes, as it were, on those issues. And so then it does fall to the president to act where he believes it's in the interest of national security to protect the United States. So, look, and we can discuss whether or not it's entirely high-minded all the time, but I do think that in large measure we have seen going from it's a very interesting kind of departure, right? If the Congress brought us the War Powers Act because of their view that they were not in on the deal when it came to the Vietnam War. And so they said, we're going to have this legislation that's going to require the president to come to us. And then they've spent the last several decades avoiding taking that responsibility that they implemented with that statute.
Yes, I mean, this is a difficult problem, again, going to the scale issue and the uncertainty issues. If you go back to the original constitutional framework, Congress shall have the power to declare war. This is a detailed and exhaustive analysis of how this is to be done in 2 words flat. We don't even know for sure whether the declaration of war has to be express or implied. And if it turns out it's implied, we don't know exactly how or what you infer the implication from. It could be a military appropriation or some other kind of nod or approval. So you have this situation. It then gets only worse as you move on, because there's the second problem, which is you do not have to declare war on somebody else if they have waged war against you. You can just go right after them, and that has been perfectly true since the beginning, and everybody flagged that one at the time of the constitutional debates. But the debate over the war powers and the use of self-defense is very similar to the debate that you see in connection with Article 51, I think it is, of the UN Charter, is when is a nation allowed to act on its own behalf? And it turns out this is a kind of a tricky question, because yes, if they're blockading you and they're bombing you, yes, but suppose to take Grotius's example from 1625, they're just massing troops on your border, and if you just continue to wait, they will outweigh you and win by, as it were, by exhaustion and attrition, or are you entitled to take action? Well, there are more and more cases that fall into this. Then I think that what Bob said is absolutely true. Everybody got terribly burned by the Iraqi war in the sense that they believe the declarations about the WMDs, then we go in, the war is successfully conducted, the peace is a disaster, at least for the first several years. And one of the things, of course, that nobody agrees on is whether or not when you authorize the war, you were authorizing the Bush policy after it was won, whether you were offering the change in the Bush policy in the last 2 years of his administration. So my view is there's no code that's going to solve this particular problem. I agree with Lisa that there's a certain degree of abdication, but given the size and the diffuse nature of the Senate, I think, in effect, we have a kind of an implicit constitutional amendment, which we started this discussion with, which is mainly the center of gravity inexorably sits back to the president, more, I think, in foreign affairs than in domestic ones.
Yeah, I don't have a lot to add to that. I agree with what you both have said about abdication. Where national security and justice issues intersect, which is what I know a little bit more about, Congress doesn't always acquiesce, depending on who the president is and depending on what the issue is. And the example that comes to mind, and Lisa knows this a lot better than I do, given her time at the head of the National Security Division in the Justice Department, there came a time where there had to be a decision about whether or not we would try people who were responsible for terrorist acts against this country in a civilian court or keep them in a military tribunal forum in Guantanamo Bay, Cuba. And for a period of time, it was permissible to bring people from Gitmo to be tried here. And one such person was brought here over time, Ahmed Gailani, whom my office prosecuted, and was convicted of one count and got life in prison. And then members of Congress did not abdicate in that particular context and decided to make it absolutely impossible for the president, who was Obama at the time, without going through a very sort of painstaking, long, bureaucratic notification procedure and a lot of other bells and whistles, to bring anyone else from Gitmo to be tried here. And I know different people have different views about that, but on the question of who asserts power, the president or the Congress, there are opportunities for Congress to act when they want to act, when it's in their political interest, and don't abdicate, and presidents have to deal with that. Now, the president did find ways, with assistance from other people, to exert himself and assert his presidential power, not necessarily with Gitmo, but through executive order, figure out ways when terrorists were captured on foreign soil, how to I don't want to say avoid or evade the congressional mandate, but sort of work through the interstitial, discretionary aspects of it to assert his will to try certain people who are national security threats in civilian courts. But there are occasions when Congress knows how to do it and occasions when they abdicate.
Sorry.
You go ahead.
I would just say one other thing about this, which is, I think it is not entirely a theoretical discussion or point to be made. In other words, there are, I think, real reasons why it is important for Congress not to abdicate. In the case, for instance, of the AUMF with regard to the ISIS campaign, I think the reason that the Obama administration put forward a separate authorization for the use of military force, even though the administration was conducting the campaign against ISIS under the original authorization for the use of military force, because it was important in the administration's view to show both branches acting together when conducting the gravest operations that we can do, when putting our men and women into harm's way, showing that resolve in both branches of our government to both the American people as well as to our allies and to our adversaries. That, I think, can and should be a very powerful point, and one that is not something that you would get into when you talk about the legal kind of particulars.
Yeah, I have, as the world's leading expert, having taught military law once this past year, one of the reasons I taught it is because I never quite understood all of this stuff, and now that I've taught it, I understand it a little better, but not all that well. But just because you say Congress is going to intervene doesn't mean it's going to do anything right when it does intervene. So the combat status review tribunals that they set up in order to give expedited hearings to people, which essentially stripped them of all their essential protection rights and so forth, was done at the instance of Congress, supported by the president and imposed by the military folks. And their basic view on this subject, we've seen a lot of stuff like this. Our procedures are very different from those in civilian courts. We're a unitary operation in which separation of powers doesn't hold any particular weight. So what we do is we build in other procedural counterweights in order to deal with this. Let us do it by our own procedures. We don't care whether they're citizens or whether they're not citizens and so forth. We think we could do it right. And that was smashed. And then you get the bunch of cases in the Supreme Court, Hamidi and so forth, and you see it. So let me just tell you one ironic story. In the, I guess it was the Hamdan case, Neil Katyal and I wrote a joint brief basically protesting the stripping of due process requirements from these various parties, and doing so on the grounds that you haven't provided a sensible substitute, so therefore it was suspect. And then we are going off about 4 years later to receive a prize for doing a great collaboration between a person in public affairs and an academic and writing this, and Neil couldn't come. Well, why couldn't he come? He was working at that time in the government, and he was going off to somewhere in the Second Circuit to defend the government when it wanted one of these really tough orders to make sure that the person in question did not get any kind of procedural due process. And there's a lesson here which is when people go into government, they kind of lose their moorings. My favorite example is also Harold Koh, right? You know, he was out there always being a critic of this, and then he basically decides that it's okay to do the fight in Libya because it isn't hostilities. We're shooting at them, but they're incapable of shooting back at us, I think was the basic explanation. So the problem here is much more acute in the following sense, and another sentence, is Congress may well want to get involved. Separation of powers may be a good thing, but it's awfully hard, it seems, to get anybody in any branch of government with the clarity of vision and the consistency of sort of long-term values to actually get it right.
On behalf of Harold Koh and the person who was White House counsel at the
I
time,
wonder who that would be.
I wouldn't characterize his position precisely that way.
Close enough for government.
But if it was indeed that position, it would certainly have been wrong. But
I also suspect, Bob, that Neil would take exception to characterizing his advocacy in the Second Circuit as trying to deprive anyone of their due process rights.
he probably
But-
wouldn't agree to that either.
It's just,
It
no,
just-
it's the strange bedfellow problem.
Yes.
I think it's a serious, serious issue, is people who are very much alert to the dangers of excessive concentration of powers when they're outside government tend to basically take a very different view of the world when they're in power. Sometimes they're right, often they're wrong. And of course, I can do this with complete neutrality since I have no power outside or inside government and count myself, therefore, as an independent expert.
The one thing I would say to that, I mean, of course, Richard is right as a general matter. One's got to be worried about, you know, the problem of where you stand is where you sit.
Yes.
But the obligation that attends to those in government to maintain the institutional position, good reasons for that. There are very good reasons for that, and not throwing over institutional positions, which I suspect is what Neil was doing in terms of defending the Justice Department's institutional position. You know, we shouldn't just kind of gloss over the importance and the value in that as well.
Preet?
I was just going to say, with respect to this debate, you know, part of that is what some people call lawyering. And in a different context, look, it's a totally different context, but I don't largely consider people who were great advocates for public safety and prosecuted individuals and enforced the law, that when they went to become criminal defense lawyers and make, you know, decent wages after that, that they necessarily lost their mooring. Some of them did. And likewise, when people who were in private practice and defending people in the system go through a different door in the other direction and become prosecutors, there are, I think, former colleagues of theirs who thought they lost their moorings. I think that sometimes happens also. But I also think, in agreement with Lisa, that people, you know, play different roles depending on where they are, and they have to stand up for institutional norms and standards as well, you know, consistent with their conscience.
That last phrase is complicated, but look, to give you but another illustration, and you know this better than I, government officials are often quite passionate in the defense of deferred prosecution agreements, right? And then they go out and they work on the defendant's side, and all they can do is talk about coercion from deferred prosecution agreement. It's very, I mean, I agree with you that in individual cases on the facts, you should certainly play the lawyering game. I tend to think that the inconsistencies often go back to first matters of principle, and it's very hard to avoid that. And what makes it even more difficult is you're not quite sure which of these two positions they're taking are right in any particular case. Is their government position or their non-government position? Being a public servant is extremely hard. Being an academic is a lot easier.
Let me ask another question again, because I want to focus on sort of, people might imagine that if we change the president, you know, we change the set of issues that we're talking about here. So I've sort of wanted to continually go back and forth between what are the individual pressures from the individual administrations on these developments, what are in fact trends in the political culture, institutional pressures. One of you mentioned in one of your answers the declining role of expertise. So just as we might see norms as playing a role in constraining the president, we might also see expertise as playing a role in constraining a president. And yet, for example, we've recently seen the State Department basically, I wouldn't say emptied out, but significantly thinned out. More and more of foreign policy activity is being conducted out of the West Wing of the executive branch, not by the State Department. And not only that, but there are people who don't have particular expertise, And I don't think they would deny it. I don't think, for example, if Jared Kushner, an alumnus of this law school, were here today, he would say he's been an expert on Middle Eastern policy or on the U.S.-Mexico relationship. And it's not the only case where people have come out of a campaign and out of the president's circle into positions of very significant responsibility in policy. Why do you suppose we see both the rise of presidential power and the decline of respect for expertise?
I guess my turn to go first. I think part of the problem turns out to be that if you're going to try to concentrate power at the center, then you have to be deeply suspicious of the area depth. So I will tell you a story that George Shultz told to me, one of our more successful entrepreneurs. He said that when he was Secretary of State, everybody would try to bypass the office and go to him to get an immediate and quick response to a particular problem. And every time that happened, George said, I have to first refer this down to my expert on the XYZ area desk, and when he gives a report, I'll get back to you. They then quickly realized that if they did this and added an extra step, two things would happen. It would take longer to get it done, and they also would earn George's presumptive disapproval on this kind of thing. So what they did is they went down to the desk, and those desks then felt that they were empowered to get their kind of expertise and go for it. And I think, in effect, even though the State Department is centralized, that's a very good model. And if somebody then comes along and says, oh, here's a document, he says, take it, I'll read it, it turns out you cut out the people who know the most in an effort to get a political decision. And in the end, even if you don't thin them out, as Tillerson tried to do, they will leave voluntarily. So I believe in real specialization for area. But there's the other side of this coin, which I think is equally important in public administrative law. I think the notion that questions of law that could be decided about the scope of administrative and judicial power should be decided by courts, not by administrative bodies. The Chevron doctrine on that, I think, is abjectly and completely wrong, because that leads to politicalization of things in which judicial expertise matters. So it's just because you're talking about expertise, you have to think long and hard as to in which particular cases it ought to be located in which particular part of the government.
Lisa and then Preet.
I don't know the answer to your question. I will speculate that there has been a kind of a primacy placed in this administration on bringing people in from outside of government who've never served in government as a kind of privileging that as a part of the resume. Which is not to say, quite frankly, that outside thinking and other experience isn't vitally important in policymaking. It absolutely is. But so too is having expertise. And I think that there has been a conflation of expertise, subject matter, civil servants, subject matter experts who are civil servants, with something called the deep state, which is, I think, a profoundly troubling use of that terminology. A very brief story. I spent 15 years in the Justice Department before I went down the street to work in the White House. I had honestly not heard, I think, or not understood what the term deep state meant until I got to the White House and started receiving briefings on some authoritarian regimes and the intelligence apparatus within it seeking to do their will, places like Egypt, places like Turkey, et cetera. That was my association with the term deep state until 2017. And to hear that term, those terms being used about the civil servants and public servants, I think is really quite dangerous. And it has sent a signal that there is not respect for or inclusion, and we've seen this in examples like the travel ban, et cetera, and the damage that rejecting that expertise and not having that expertise in the room, the damage that does to substantive policy decisions.
Preet?
So, I don't know that it's true, the seeming premise of your question, that over time there's been a correlation between increased presidential power and decreased expertise. And I haven't studied this deeply, but for example, I think a lot of people could argue that the Obama administration, I think that was the premise of the opening statement, that the presidential power has become more expansive over time, including over the Bush administration, the Obama administration. And my anecdotal memory is that President Obama cared deeply about experience. If you just look at the Energy Department, we had, people who had won the Nobel Prize and had PhDs, and that office is now held, I don't know for how long, by someone whose degree was in animal husbandry. And so I don't know that is actually correlated, with each other. I will also say that, and maybe this puts me in a minority, I think we can overstate the importance of expertise and understate the importance of professionalism, temperament, judgment, intelligence. I think there are lots and lots of examples, if you pick the right person, of people who have all those qualities I just mentioned, and you put them at the head of an agency over which they don't have deep, deep knowledge, but they have otherwise an understanding of how politics works, of how government should work, of what the right thing to do is, they can be quite successful. A quick example, Leon Panetta, I think is one of the finest public servants that we've ever seen in this country. I have deep respect for him. He gets nominated to be the head of the CIA, even though he had broad experience in the Office of Management and Budget. He was a congressman, White House Chief of Staff, and Senator Feinstein, a member of his own party, immediately came out with a criticism of him because he didn't have what she thought, I don't remember the exact word she used, didn't have a certain kind of expertise in intelligence matters because he'd never been at the CIA. And I understand the criticism, and it's kind of the thing we're talking about here. And I think Leon Panetta was viewed internally and externally as an excellent director of the CIA. He's the only person that I believe, and you'll know better than I, but I find it extraordinary that someone like that, who then moved from the CIA to the Defense Department in the age of acrimony over Barack Obama and the Congress, I think was confirmed unanimously by the Senate, which doesn't happen much, because I think he had the qualities of understanding how to be a public servant and judgment and everything else, which is not to say that you can pick anybody from any place if they're wise and smart and have them lead a place. What it does require is whoever you pick at the tops of agencies have to, go back to what Richard said, in part, you have to know what you don't know, and the people that you put in charge of things, even if they themselves don't have expertise, they have to believe in, at some level going down, in expertise. Yes. And so I'm much more concerned about a president deciding to put in charge of various large agencies at a very high level. I'm less concerned about those people not having expertise than I am about those people not understanding that expertise is important to getting policy done the right way.
Right.
That is 100% right. I will tell you a story. I have stories. I had executive power once for 3 months as dean of a law school, and in my first 3 hours, I made many, many mistakes. And then Jesse Jackson Jr. walks into my office, and it's a meet and greet. And so I said to him, look, let's just cut to the chase. I've been in this office for 3 hours, and I'm making a bunch of mistakes. What should you do? And this is what he said. He said, if you're the chief of a business, he says, it's not your job to know everything. And quite the opposite, it's your job to hire people in every office who know more about what they do than you know about what they do. And then he put his hands like this and he said, and if you don't know that, then what happens is the limits of your office or staff is the limits of your brain, and that's just too small. And he said, the second thing you have to know is that when you do appoint these people, you always push them to explain more, and then they always develop their expertise better, and they come back and they teach you, and you make it into a virtual cycle. Well, I mean, I don't agree with much of Jesse Jackson Jr.'s politics, and I'm sorry about his personal demise, but it was the best piece of advice that I ever received, and it was just completely fortuitous. And so 16 years later, I will share it all with you.
Jonathan, do we have time for one more question before we open it up? I'm not sure when we got started. Okay.
We have like 20 minutes left.
Total. Okay, so I think we'll do one question, then we'll open it up. I do want to, if I could invoke moderator's privilege here and just respond on one point, which is that all works if you have cabinet government, and where the Congress collaborates with the president in appointing, in basically supervising who's appointed to the key agencies. If you have West Wing government, in which the White House proposes to control absolutely everything, does not want the agencies fundamentally to function with too much freedom, because in their view, and this I think has been true of a number of presidents, the agencies produce only trouble. Policies work their way slowly but surely through the agencies, and then suddenly one day some agency rulemaking or action shows up on the front page of the newspapers, and it's a political problem for the West Wing. So they want control over the agencies, and they don't necessarily want strong cabinet heads. They want, for example, czars or others in the White House to basically control particular subject matter areas for which they feel they're specifically accountable. And that has the effect of not only aggregating more power in the West Wing, but it puts more political people that presidents personally trust and know into positions of responsibility and devolves the power away from the agencies where presumably would want a lot of sort of career expertise to reside. So that was sort of the premise of the question. And the institutional way in which that can come about, I don't disagree about with what Preet says about the importance of individual temperament, and it's absolutely true that President Obama had a very tremendous amount of respect for expertise, and that balanced things out because it also meant that people with expertise were appointed within the West Wing to advise, and not simply out of a circle of political supporters.
Can I say one thing about that, Bob?
Yes.
I think there's a distinction, though, on the domestic policy versus national security and foreign policy issues, right? I completely agree with the danger you highlight of having centralized kind of West Wing control of domestic policies, et cetera. I think the other reason, and my experience in kind of the foreign policy and national security realm in the West Wing, there is very good reason to have subject matter expertise around the Situation Room table to guide your decisions, whether it's on counterterrorism operations or foreign policy decisions. One, because you want to make sure that you're informed by experts with deep intelligence and diplomatic analysis and the like. The other is because you want to make sure that the decision the president ultimately takes is actually has some buy-in by the rest of the government who needs to carry that out. So, call that cynical. You might also call it good government, right? To make sure that people feel like they are part of a process and then are marching in unison to implement the decision, even if some agency might have wished the decision went the other way. If they feel like they were invested in the process, you have some certainty. If you're part of that West Wing cabal, you have some certainty that they're going to go forward and implement the decision.
That's true of every business.
Yeah.
Anytime you have hierarchy, you have to have buy-in at the bottom, or you can't get the commands executed.
Okay, so with that, I think there's a lot more to cover, obviously, but then we wouldn't have time for questions. So let me open it up for questions for the panel.
Go to the mics.
There's a mic right behind you.
Mike.
Right. There's just a standing mic over there.
Yep.
No, there's a mic over here.
If you go around the corner, right at the end of the aisle, you'll see the mic. Sorry.
Thank you. So the first part of the discussion, you were talking about the line that the president may cross under certain circumstances in dealing with the Justice Department. So the question I have is, and I apologize if this question is answered in the materials that were distributed because I haven't read them, but is there judicial authority, Supreme Court or otherwise, that sort of define that line or address circumstances and give us some sort of guidance from a judiciary on when that line is crossed?
A professorial question. There was, of course, an effort to do this, and that had to do with the case of Olson against Morrison in 1988. And Justice Rehnquist, who was by and large a big government supporter on these issues, essentially took the position that until you got to some very extreme positions, it was a matter of political largesse and presidential judgment on all sorts of issues having to do with removal and oversight. Justice Scalia, in one of his immortal opinions, had the classic line in dissent, "This is a wolf in wolf's clothing," and he thought the excessive power in that particular office, and it was shut down by legislation in 1998. But I think that A, the particular precedents in this area, and B, the general administrative law move towards deference with respect to these kinds of issues suggests that the courts would probably stay out of it until you get into some very extreme type situations. There are a number of very active discussions on impeachment which tie into this. And I think to the extent that you're talking about distributions of powers, you're not close to the line. It would have to be essentially ordering somebody to prosecute somebody whom you know to be innocent or not to prosecute somebody whom you know to be guilty. That would start to raise that flag.
To kind of just pick an example.
Yes, to
Yeah.
pick two examples at random. But I think that the law on this stuff is the courts are marginal players and that the dominance will be between the various political branches.
I have a footnote, but I'm going to defer to Preet.
No, go ahead.
My footnote only was, the one thing I thought came to mind immediately was the courts have definitely policed presidential intervention as a form of self-dealing. So, for example, the Nixon tapes case is an example, where the President of the United States tries to intervene in the criminal justice process evidently for the purpose of, or it is alleged, as in Nixon's case, I think established, for the purpose of protecting himself and close associates from political liability. I do not believe, and correct me if I'm wrong, Preet, Richard, Lisa, that right now in the hypothetical I gave earlier, the president picks up the newspaper, has read about, pick whoever you want to pick, pharmaceutical company executive Y, widely unpopular, right? And no action has been brought about that, against that particular individual, and there's an outcry about the fact that that particular individual was a pirate, and something should have been done about it. It is not illegal for the President of the United States at the moment. It's a violation of a norm, I would agree, but it's not illegal for the President to pick up the phone and call the Attorney General and say, I do not understand, based on what I've read about X, I do not understand why you've taken no action against X. How can that possibly be?
But it's not illegal to say, I don't understand what's going on. Could you explain it to me?
But it's not illegal to say even more than that.
No, but I'm saying not, but the
Right.
thing that I said is not a violation of norms either.
No, not at all. And so
Yeah,
what we
I
have,
agree.
do you disagree?
Yeah, no, I don't disagree with that. No. I mean, you can't, on this, as we transition to this idea of what norms you codify, you can't codify them all. You end up, I think, with government that's worse, in the same way that you can't prescribe a rule for every bit of conduct on the part of, your C-suite at a company, or for students at a law school or a college, or for criminal conduct general, for prosecutors, you have guidelines. If you start codifying everything, I think you end up worse off.
Yes.
Or you have a false sense of security that by codifying, you've kind of fixed the problem. If you don't end up having, institutions are ultimately just made up of people who either observe those norms or they thwart them. And no amount of codification changes that fact.
Yes, and if you decide to sweep, take a broom and sweep clean, one of the things that you run the risk of is a complete loss of institutional memory. Some of it actually matters on the ways in which these things ought to be done. I mean, one of the nice sort of constitutional experiments that you can do by way of a thought situation is to think of interactions between the president and the Congress and figure out how many of them are completely unspecified in terms of the Constitution on such matters, for example, as executive privilege and so forth, and how much consultation you want to give in various ways. All of these things are done extensively, and they are all done essentially by customary practice. So if somebody comes in, I won't mention any names, and is either contemptuous or ignorant of those things, then everybody else is going to have to figure out what you try to do to cover your tracks when this fails. And generally speaking, when people are trying to adjust not to the sensible behaviors of others, but to the silly behaviors of others, that's where there are all sorts of disagreements about what's the best way to counter this mistake by the president or the chief of the Senate or so forth. You then get fights over collateral issues, and by the time you're done, there could be an enormous amount of disarray. It's much easier to keep the train on the tracks than to try to figure out how you put it back after somebody has decided to take it off.
If you flip your hypothetical for a second, it becomes a harder question. So your example was president calling up and saying, what are we doing about this, named company or named individual who's head of the company. If on the other hand, there was reporting that this company might have been engaged in bad conduct, and the president calls and says, let me tell you something, this is nonsense. I know that guy. I know that company. Lay off.
Bad.
That's
Yeah.
right, but it's the same issue. One is affirmative conduct to try to protect versus affirmative conduct to try to prosecute, and it makes a big difference.
Well, it comes down to something fundamental that I think everybody who's served in government believes that it cannot function without, and that is good faith. Any other questions? Yes, sir.
Are there any limits on the president's pardon power? And can that be obstruction of justice?
That's an academic question, I think.
That's a Bauer-
That's totally academic.
That's a Bauer question.
Look, the answer here is twofold, legal and institutional. as a legal matter, if you look at the pardon power, it is described as a power in the Constitution. Being commander-in-chief is not a power. It's an office, and it makes different. And I think it's widely understood that there are no checks from any other branch of government with respect to its exercise. On the other hand, as a political matter, most presidents realize that unless you have some kind of institutional process working up to the particular office, what you're going to do is to make a series of decisions that are going to be erratic, indefensible, and put you into terrible political problems. And so what happens is this is a classic case in which having too much power is actually a liability rather than an asset. And so what you do is you form an office of the pardons. Then the question is, that's a big job, how do you fund it? So one of my former students, Deborah Leff, was the head of that office, I think, and she thought that there wasn't sufficient funding to give the examinations, and there wasn't clear directions as to what classes of cases should be done, and resigned in something of a sort of a public huff about the whole thing. You then get an appointment and so forth. So I think the answer is no. You don't do it unilaterally unless, and then you take the most famous recent pardon, the Mark Rich case, right, under Clinton, and people start to say this causes a huge amount of illegitimacy to the office because it's figured in some sense to be a political payback of something else that has happened. So I would say that any president would be well advised before doing anything like that to refer it down to somebody of an independent office, and the more serious and individuated the case, the more detailed the briefings you want before you act.
That's what happened with Joe Arpaio, right?
Yeah, right. I think
Let-
the more recent example might be Joe Arpaio.
Oh, Sheriff Joe, oh, I forgot him.
Yeah.
Yeah.
Better left unsaid.
Can I introduce, let me introduce a dissenting
That was
note here.
before he was tried.
Let me introduce a dissenting note here, which is, if I understood Richard correctly, but I understood what the panelists say. I actually do, my understanding, my reading, and I did look at this, but I was never required to opine on it officially. I'm pleased to say nobody came in my office and said the president wants to pardon somebody. Can you please tell us whether it would be obstruction of justice? Fortunately, that question was never put to me, but I understand that the pardon power is presumably absolute with respect to the person to whom the pardon is granted. That person is pardoned. I do not see any basis for the argument that the president, in a case where the pardon is an act in furtherance of obstruction, that the president isn't criminally liable. I think, in my view, there's no case law that I can find and no constitutional reading that I can see that insulates the president from liability for the misuse of the power. The power is absolute with respect to the beneficiary. It is not clear to me it is absolute with respect to the president.
Well, it's not going to be absolute with respect to the beneficiary if in every case you can have a collateral attack in or after office. And my own sense is I think the obstruction issue is very much on everybody's mind today. And what I would do is I would essentially use it for manipulation of other people in other offices, asking them to deviate from their duties. And I think it's going to be much harder to do it in this particular area. And the danger is the expansion. That is, all motive tests with respect to complicated actions are going to founder on dual motive type situations. So my sense about this is you have to go carefully, and there is no authority on this, and I treat that as a kind of an implicit acknowledgement that obstruction of justice does not apply there, although it does apply, as we know, to executive privilege claims of the Richard Nixon variety, which was uniformly and rightly rejected.
So I agree with you in the abstract, and then I agree with you even more if we decide to create a hypothetical and load it, as you said before. So if there's evidence that a president who is under investigation decides to wait it out and see if some other person who might be able to provide incriminating evidence against the president that we're talking about, and see if that person is going to cooperate with the government or not, and then you have evidence that the president gets word that that person is going to cooperate against the president has reason to believe that he himself is maybe in some jeopardy, and decides and documents and tells to other people that the reason he is now pardoning this other person is because that person will then no longer have any incentive to cooperate, although I know there are different arguments you can make about, but to take it on its face. And
But
you
he
have,
also has no incentive not to cooperate. That is,
Right, no,
he
no,
can't
yes.
plead the Fifth Amendment
Yes,
because
correct.
he's free from all that stuff, so you
Correct.
could really start to go on it.
I was trying to read that out of the hypothetical, which is
Yeah,
the point I was just making.
this is basically
Right.
an argument, we're going to plug one hole in a sieve and hope that the rest of them will somehow or other magically disappear. It's not going to happen.
The only point I'm making is, if you have a series of facts that suggest that in the mind of the President of the United States, he decided to grant someone a pardon because he thought that it would stop a proceeding that was not yet complete, and that proceeding, if allowed to continue, might incriminate himself, you've got a better case, and there are people who would, I think, take that case up.
Yeah.
I'm going to talk about the elephant that's in the room. I started at this law school shortly after Archibald Cox was fired, and he, in fact, gave the keynote address at Rutgers that year when I graduated and got my master's degree. And at that time, we did not have at NYU, or I think at any law school, a requirement to take professional ethics. We are now in 2018, and we have a special prosecutor living under the specter of being fired at any time. I'd love for all of you to talk about the power of the presidential pen in this context, please.
Who wants to go first?
Why don't we start with Preet, move down to the end, and if I have something to add, otherwise I'll lay my sword down. Go ahead.
I mean, I'm not, if the spirit of the question is what will happen if that takes place, I don't know. We talk about congressional abdication in a different context, and I think we might be in a position to talk about congressional abdication in this context. And if you want to read some handwriting on the wall, or the tea leaves, or whatever metaphor you want to use, I agree with the people who have been speculating since Friday that they should not be prepared for a very strong response from Congress based on what the president did with Andy McCabe, the deputy director of the FBI. Congress acts, when you talk about the relative strength of our institutions, I think the press is actually in very good shape. I think the judiciary is in very good shape because structurally it is protected. I think the Department of Justice and the independent function of law enforcement is in jeopardy. And Congress, I put in a different category because it depends on their view of who's up, who's down, when the election is coming, and what they can allow a president to get away with or not. If you asked me this question 2 months ago, I felt that the feeling in the air, the ether, if you're reading the ether, was that the firing of Bob Mueller would create a gigantic uproar, not only in the streets, as people suggested they would take to the streets, but also by members of Congress, and not just people named, Flake and McCain, and some others. It's been very, very quiet. There have been very few people who have expressed the concern that you just expressed at the microphone about the prospect of Bob Mueller being fired.
Oh, my God, that comes to me going down the road. I think that basically there are two scenarios, and we don't know which of them is true. So, and with both guys, McCabe, there is supposedly a report, and no one has seen what this report says. And if it turns out that it looks rather flimsy, it may lead and provoke some very strong reaction. If it turns out there were some serious irregularities in terms of concealment, which is what Sessions indicated without explaining, I think it's going to be much less to do so. With respect to Mueller, I've been in a couple of conversations in the last several days with people who are quite passionate on this subject. I would say almost obsessed. And there are two different stories that you can give, and I will give you both, and then you could figure out which is plausible. One of them is that Mr. Mueller is a genius. What he's doing is one thing after another, putting the blocks together in a way that you would find admirable, block after block after block, and then when this giant machine is together, he's going to drop it all in such a way that nobody will be able to resist the force of his argument. That's view number one. View number two is the guy had nothing, the guy has nothing, he's not going anywhere fast. The reason he's taken 9 months is because he wants to basically draw out the pain of the president. And when it comes out, he's going to give another collateral consequence prosecution of some guy for lying to the FBI. If it's the second story that's true, there won't be much of a fight. If it's the first story that's true, I think you better head for the air raid shelter.
I think, and I described it this morning this way, that were the president to direct Rod Rosenstein, which is how this would have to be effectuated, to fire Bob Mueller, and were that to be carried out, that would be a gut punch to the rule of law. It would send a signal to the United States, to the world, quite frankly, that we're not, in fact, a country of laws, but rather one ruled by an individual who believes in fiat and that he is in fact above the law. I think that would be catastrophic for the rule of law in this country. I'm actually not one given to hyperbole, but if that were to take place, I do think it would be devastating. And I am not particularly optimistic, based on what we've seen thus far, as to Congress's willingness to step up. And so that is deeply concerning, that what we saw on Friday night, and, you know, I think some people are overreading that, the firing of Andy McCabe, as a kind of presage to firing Bob Mueller. But the events of Friday night are disturbing for another reason. The merits of the action taken against McCabe are impossible to assess, because we don't have a public airing of this Inspector General report. I will say, as an aside, as somebody who spent a lot of time in the Justice Department and read and reviewed and participated in the review of dozens of Inspector General reports, I think we have some very concerning elements here. The fact that that report is not public now, and the usual course is to allow the subject of the investigation to submit a detailed response, to be printed, and to appear in, as part of the Inspector General report. The fact that we have not seen that, the fact that the investigation of McCabe was kind of hived off and accelerated from the broader investigation of the Clinton email, the conduct of the FBI in the Clinton email matter, and then the fact that it was done Friday night is just, all of that is, you know, kind of stinks.
Could I ask you, this was my solution to the problem. You don't want to have the investigation short-circuited because of the retirement benefits issue.
Yeah, right.
So what you should do is announce that what we will do, make a deal with McCabe. He will essentially agree not to retire and cut full benefits until this thing has run its course. And then if it turns out that the reports are not adequate and he's responded, he gets his pension, otherwise not. Is that a fair way to try to do this, to toll the statute?
It's certainly possible. That's certainly one way to do it. The reason I lay all that out is because the damage, the immediate damage, of course, is felt personally by McCabe and his family. Okay. The long-standing and long-term damage is to the institution, because this process, regardless of where the merits fall out, were irretrievably tainted the minute the president started publicly calling for McCabe's ouster and publicly calling for his pension to be stripped from him. And that has a long-term impact and taints and puts a cloud over the work of the individuals in the Justice Department who, let's give them the benefit of the doubt, did a thorough job and a thorough investigation and have rendered a thorough and appropriate conclusion. But the problem is nobody can have confidence in that, because the norm that we've spent the last hour plus talking about, that is supposed to have a wall between the White House and the presidency and the law enforcement decisions, including personnel decisions, has not been observed here.
And once again, this is another example of where it's also bad for the president. I mean, maybe some
Exactly.
people in his base, to speak politically for just a second, are heartened by his vindictiveness. And whether or not, I mean, I guess, I don't know. But it means that every other time, you know, the next time there's something where someone has transgressed, look, part of the reason why Andy McCabe, who I know personally, so I'm not a completely unbiased party here. I worked cases with him, and when we were both young and line assistant and line agent on Russian OC cases, and I know him very well, and I think he's a great person. It seems like something went awry
Full
here. I don't know if-
disclosure, I'm in the same,
Yeah, and
same category.
and I don't know
never
about
met
that.
the guy.
But part of the reason that it stinks and people are coming to the defense of Andy McCabe, who, unlike Lisa and I, don't know him, is because the president has done other things like this that suggest that he is capable of acting with great retaliation, vindictiveness, you know, not respect for the law. And this is another example of that, whether it's right or not, that will cause, you know, to the extent he wants to persuade other people that he's doing things by the book in the right way, it will cause, you know, other people in the future not to believe in the propriety of his actions going forward.
And let me
And let me-
just add one remark. I have never had an association with the Obama administration, although I've known the president a long time through the UFC. And I support many of the Trump policies that many people here would find disagreeable, although I disagree with him violently on a number of issues. But I just don't think he has the temperament to be fit for this office, independent of the substantive position. And I've said that for a very long time, and you're just hearing particular manifestations, but this also applies in connection with his relationships with people from other countries and how he sort of respects and deals with them. And the whole thing essentially is a person with this dominant a personality simply sucks all the oxygen out of the room, which means that other people cannot effectively live and breathe. And that's a serious tragedy.
Let me just mention one concluding remark about this, and that is, particularly for this audience, and here we are at a law school, the question that you raised originally about Watergate and the lack of professional ethics among lawyers, many of whom went to jail, including the Attorney General of the United States in that episode, does suggest that we need to worry about the ethics and how we're articulating the ethics and enforcing them in government service. The canon of ethics speaks to mostly private lawyer conduct, and I do think that we need a more developed ethical framework for how lawyers and the government operate. Certainly, White House counsels, for example, as appointees of the president, could use that sort of guidance, I'm sure. But the second point I want to make is that civil society has a role to play here, too. And so if there is not an uproar, ultimately, about the firing of Bob Mueller, the question is, to what extent does the civil society at large share some of the responsibility? Where's the bar associations in the community? Where's the community leadership? It seems to me we've lost a lot of that in recent years for reasons that are too complex, both for me to understand and for us to cover here this evening. But you would want to see institutions of leadership outside the government, the ecclesiastical, legal, you name them, standing up for some of the norms that we're talking about and providing some leadership here. It cannot simply be an argument between the two political parties, the team with one jersey, the team with the other jersey. And I would be very, very disappointed if there wasn't a stronger institutional response outside the government, American Bar Associations, community organizations, and whatever, that articulated a general sense, which I think politicians would respond to, that there are norms and that in a case like this, they're being transgressed. And so I think, as always, it's easy to blame the politicians, but sometimes the general public shares some of the blame as well, and the leadership and other institutions ought to be heard on this topic as well. And Richard, I can tell that you're...
Yeah, no, I want to say one thing, and this is not in defense of Trump, but I thought it was a serious mistake in judgment to take somebody who was close to the FBI to run an investigation which will necessarily implicate the behavior of people in the FBI. And I think one of the consequences of this decision, whether you think he's the best guy in the world or not, I have no opinion on that, is it gives the people on the other side a leg to stand on when it comes to the debate. So if you had taken somebody from a large private firm who was used to fraud and complicated investigations, say, you run this kind of thing, you don't have any baggage, you're not close friends with Jim Comey or McCabe or anybody else, I think it would have been a little bit better. But one has to, I think, recognize that, as I said, the breakdown with Sessions and Rosenstein and so forth, this is part of the price that you pay for those original decisions. And, you know, maybe this was the right choice, but my own view about this is you can't avoid witnesses with conflicts, but you can always avoid people taking offices with conflicts, and that what you really want to do is to get somebody who, as you said, this is you, who understands all of this stuff but has no particular baggage or connections, because you could hire the staff and learn the things. But look at the criticisms of Mueller. He's hired only Democrats. I don't know whether this is true or false, but this is what's going to make it harder to do what you want to be done, and which may well be right. So I think it would be a terrible mistake for the president to fire Mueller at this particular point in time, and it should provoke an enormous reaction. But I do think, in effect, that there's a kind of a Greek tragedy quality to this whole thing as it started to emerge back from November.
Can I say 30 seconds?
Yeah.
I understand what you're saying, but my concern about the country is you could have picked, brought back from the dead the leader of a religion You could have brought back Abraham Lincoln. You could have brought back George Washington and put that person in the position of investigating the president, whom tens of millions of people don't want to see go down, and tens of millions on the other side want to see him go down. And I think it's an impossible task. And one of the reasons I respect Bob Mueller so much is that he took the job, because he had a nice life. He did a lot of public service. He defended the country in war. And he is going to go down in some measure as a divisive figure because of the nature of the job that he decided to take on.
I would rather take my chances with an unknown. I think there'll still be fierce opposition, but it will resonate less with that undecided mushy middle.
I think that wraps it.
Thank you all for coming. There is a reception literally behind those curtains, and if you're able to grab one of these panelists and bend their ear, you should take advantage of that and do it. Thank you.